Now we're going to talk about the duration of copyright law. How long does a work stay protected by copyright before it falls into the public domain? Mark Twain argued that copyright should last forever. Others argued for only a few years, just enough to give authors the incentive to create. But how long does it last? It is long. It's a long time. We're currently looking at, well, from the moment of fixation in a tangible medium, it's the life of the author. So let's say a 20-year-old creates a song and lives to be 100. It is certainly within copyright protection all of that time plus 70 years. So the heirs of that individual get to reap the benefits of that work. So a long time. The book, before I move on, the book covers this pretty well, and it does have a few more examples because as you see, it's really going to depend on what statute we're looking at for calculation purposes. So 177 through 220 covers the discussion of formalities and duration. So how long does it last? Depends on when the work was created. Works created in 1920, let's say, was covered under the Copyright Act of 1909, and the copyright expired January 1st, 1977. Works created in 1921, covered under the 1976 Copyright Act, and those works created in 1921 expired January 1st, 1997. Works that were created in 1922, also protected under the 1976 Copyright Act, or at least the duration periods are calculated per the 1976 Copyright Act. And the copyright expired. Copyright in those works created in 1922 expired January 1st, 1998. 1923. Now we've had the Copyright Term Extension Act that has come into play, which means any works that were created in 1923 expired in on January 1st, 2019, or they fell into the public domain on January 1st, 2019. They expire on December 31st, 2018. So there was a big jump there from the works created in 1922 to those in 1923. And we're currently under the Copyright Term Extension Act, and we're going to go through each one of these specifically. Just giving you some background. So from 2019 onwards, works published in 1 year will enter public domain at the end of the 95th calendar year of publication. So for example, works published in 1924 will enter the public domain on January 1st, 2020, which they already have. And 1925 will be January 1st, 2021, and so forth. So works, you can way that works published before 1923 are no longer under copyright in the U.S. That's a safe bet. Works copyrighted from 1923 until 1977 may have an effective term of 95 years. I say may, because this is what governs what could be governing between this time period is that copyright notice. You have to have a copyright notice on your copyright, especially during the 1960s. And renewal. You have to apply for the 28-year renewal. So those are kind of in play. So works might be in the public domain. Works created after 1978 have a term of 70 years or so. So we're looking at 2048. Copyright was enacted. The first copyright statute enacted in 1790, the duration was for 14 years, with one 14-year renewal period if the author was still alive. If the author was dead, no go. In 1831, that changed to 20 years. There was an extension created. So it was changed to 20 years plus a 14-year renewal if the author was alive. The Act of 1909 Act came along, and it changed again. And the duration for the copyright in the statute said 28 years from the date of publication. So when it was published, not when it was created, when it was published, plus 28-year renewal if the author was alive. So the author would have to be alive to get the renewal. Then came this guy. 1928, Mickey Mouse appears. And under the 1909 Act, Mickey was protected for only 56 years, so he was scheduled to expire in 1984. What would happen? Mickey would have fallen into the public domain. But a few years before that expiration, Disney began lobbying Congress to change the act. So in 1976, Congress changed the duration to life of the author plus 50 years. And this is the duration that Europe recognizes. If something was authored, a work was authored by a corporation, the law granted retroactive extension for works published before the new act. So 75 years. So Mickey got 75 years as a result of that new act. So 75 years from 1928, Mickey was due to expire in 2003. Why did Disney want to protect Mickey? How much money do you think Mickey makes for Disney annually? Just Mickey Mouse, not every other character that falls under the Disney realm. Just Mickey. Worldwide, $5.8 billion a year. 1 year. Mickey has 97% brand recognition, which is more than Santa Claus. So since 1997, Disney spent $87.6 billion lobbying for copyright extensions. Do you think anyone lobbies for the public domain? So now what happens? 1998, the Sony Bono Copyright Term Extension Act. It's also been referred to as the Mickey Mouse Protection Act. That was passed. That created the current terms that we are under. Works after January 1st, 1978, life of the author plus 70 years. Life of the author plus 70 years. And if it's a corporation, it's 95 years from the date of first publication, or 120 days from the year of creation, whichever expires first. So that's what we're currently under. So what does that mean for Mickey? Mickey's due to expire December 31st, 2023. Any arguments for the public domain? Do you think we'll see another extension on the horizon as we roll into 2021? With each extension, there's less works that go into the public domain. Thank you, Disney. But even if Mickey goes into the public domain, all of these major Disney characters, Mickey Mouse is not only copyrighted, but he's also trademarked, which lasts, indefinitely or in perpetuity, as long as it continues to be used commercially by its owner. So whether or not a particular Disney cartoon goes into the public domain, the characters themselves may not be used as, trademarks without authorization. At least there's that. Now, mind you, trademarks. So depending on how that use is, are you using it as a trademark, i.e. publish a business that is technically competing, or would it likelihood of cause confusion? There has to be commercial exploitation or using it in a disparaging way. But suppose, for example, that you wanted to create a new Mickey Mouse toy without authorization from Disney. You'll be free to do that in 2024. There's no extension of the Copyright Act, and that doesn't look like that's going to happen. But that is only if what? Only if your Mickey looks like Steamboat Willie. Only Steamboat Willie rolls into the public domain. And as we all know, Mickey Mouse has evolved over the decades. Modern Mickey is still protected. The most obvious example of Mickey, check out Steamboat Willie, his hands, right? Mickey kind of looks, well, this is an old Mickey, but Mickey had white gloves. And he only a couple years later does Mickey get white hands or wears the white gloves. He didn't wear them in Steamboat Willie. So if you wanted to sell a Mickey toy with white gloves, you'd have to wait to actually 2025 when the copyright for the first Mickey with white gloves, the Opry House, is scheduled to expire. Early Mickeys were black and white, so if you wanted to make Mickey with modern colors, you have to do some careful research on when those colors first appeared. Despite subtle changes to Mickey over the years, they still might be legally significant. Other characters, Sherlock Holmes. The book series was published from 1887 to 1927, so most of it's already in the public domain, and there's been lots of Sherlock Holmes books and movies and, derivatives from Sherlock Holmes, except that they can only use up to the point of 1923 because the other 4 years of works are still under copyright protection. Other characters due to expire in the next 20 years, Batman, 2035, I think, for Batman, Bugs Bunny, Superman, Winnie the Pooh. All of these are all scheduled to expire. Walt Disney, however, I would not, if Mickey expires in 2023, I do not recommend to use Mickey because Disney has lots and lots of money. And the Walt Disney Corp, they become well known for protecting their copyrights and trademarks. And they will cease and desist or attempt to get people to stop using Mickey, regardless of whether Mickey fell into the public domain or not. They will certainly spend the money to challenge it. I mean, they have gone after, in 1989, for instance, they threatened legal action against 3 daycares in Florida for having a Mickey Mouse and other Disney characters painted on their walls. The characters were then removed, and then Universal Studio allowed for the replacement of Universal cartoon characters. So that's how harsh Disney is. So we'll see what happens in it'll be 2024 because it expires December 31st, 2023. Let's look at these durations. Works, this is what we're working under. The copyright statute is 17 U.S.C. 302A. Copyright begins when work is fixed in a tangible form and lasts for the rest of the author's life and then another 70 years. And if it's a joint authorship, copyright will last until the death of the last author, plus 70 years. Works made for hire. Remember that our employees of corporations, they have 95 years from the date of publication or 120 years from the date of creation, whichever expires first. So something can be created in a corporation setting and then set aside because they don't want to pursue it, and then 10 years later pursue it as something else. And also if the author isn't named, they don't know who it is, they're anonymous, or they go under a fictitious name or a pseudonym name, that's also has the 95 years or 120 years from creation, whichever expires first. Works under copyright before 1978 under the 1909 Act, the maximum term was 56 years, so it was 28 years plus a 28-year renewal, which was not automatic. So the owner would have to renew it. In enacting the 1976 Act, Congress could have left the term for pre-1978 as it was, allowing those works to go into the public domain, but it chose to give pre-1978 copyrights the same 75 years it gave to post-works for hire. It didn't just switch the term to 75 years, though. When it did, it gave a 19-year renewal. So then we had 28 plus 28 plus 19 equals 75. And then when Congress extended copyright term by 20 years in 1998, it did so by adding another 20 years to the renewal term for a total of 95 years for these are pre-1978 works. So like I said, between 1923, I should say 1924, because those works of 1923 are already in the public domain, but from 1924 to 1997, that's where this wiggle room comes in. We're not quite sure where you got to make sure things got, copyrights got renewed, and where the extension plays a point. So it may seem technical, but these things, like I said, are key to determine who had the right to renewals and whether that renewal was proper, and whether or not, obviously, the notice was put on these works to determine whether they go into the public domain. You may recall from the public domain discussion, Happy Birthday, all the issues involving Happy Birthday and who owned it and who didn't, and it was really in the public domain, and everything that had gone through switching hands. There is after this lecture, there's another video that I'm going to consider a lecture. It's also part of this week's forum post, but it takes all the concepts from formalities and duration and explains them in the concept of a real world example involving films. The It's a Wonderful Life, Rearview Mirror, and how these terms get kind of convoluted. So that's part of this discussion as well, and I think it ties all of these concepts together very well. So renewal, I touched on it in the last video. 17 U.S.C. 302E, if you want to look it up. Works made for hire, employee of the corporation. You have to do your filing. You have to file your renewal at the appropriate times. Not just corporations, but authors who may own it as well. So who does the renewal? The owner. The owner of the copyright is the one who does the renewal. So if it's a work for hire, it's the corporation. If it's the author, the creator, then they're the ones who do it. Remember, our copyright notice has to include the C symbol, the year of publication, and the owner. Now, as an owner, you have renewal rights, and we're talking about the renewal rights that exist. They existed pre-1976 Act, because the 1976 Act made the renewal automatic. So we're talking about things, pre-1977. So who renews? The owner of the copyright. Now, can you assign your renewal rights? What do I mean by assign? Can you give them away? So, you can give them away, or you can contract them out. I will give you my rights and my renewal, and you pay me X amount of dollars. So you are an author and you sold your novel and it turned into a big blockbuster hit. You reap the benefits when, the term ends. 28, we're talking pre-1977, so we're going to talk about 28 years. But you have to renew if you want to keep that going. So you renew for another 28 years and you can still continue to reap the benefits of your copyright. But what if the publisher wants to buy the novel and the rights of renewal? Can you do that? Sure you can. But what does that mean? You don't reap the benefits. You just gave them away and created basically a new owner. And then that person can then assign it to somebody else and then assign it to someone else. And that's what you'll see in the movie or in the video with regarding all those films. But the Supreme Court has limited the assignment. The assignment would not be effective if the author died before the time came for filing the renewal. The right would actually revert. Now, let me just tell you about the Miller Music case. This was from 1960, U.S. Supreme Court case. Miller Music is a publisher. Ben Black and Charles Daniels are the composers of the song Moonlight and Roses. Ben Black and Daniels composed the song, and they assigned it to Villa More Incorporated. That they secured the original copyright, the first term. And prior to the expiration of the 28 years, Black assigned to Miller Music his renewal rights in the song. Black had no heirs, no wife, no kids. The next in line were his brothers, but they executed an assignment of his renewal rights as well. So before the execution, or before the expiration of the original copyright, Black dies. And his will didn't address the renewal of the copyright. So his estate, per the will, indicates that anything he has or owns goes to his nieces and nephews. And one of his brothers became the executor of his estate, and the executor renewed the copyright for the additional 28 years for the estate, and the estate distributed the renewal rights accordingly down to the nieces and nephews. And Miller Music sued. Said no, he assigned the rights over to us. Ben Black assigned the rights over to us before he died. So the issue for the court was whether, by copyright statute, the renewal rights accrued to the executor in spite of a prior assignment by the, well, they call him a testator, by the individual who died. And the statute says that an author of such work, if still living, gets the renewal. Remember I said that at the beginning? They have to still be living. They get the renewal. You can assign it all you want, but come the renewal time, you need to be alive. And if you're not living, your heir, your living spouse, or your child gets to decide. And if you do not have a living spouse or a child, then the statute says the executor shall be entitled to a renewal and extension of the copyright for the further 28-year term, if the application is made in accordance with the statute or the registration. So an assignment by an author of his renewal rights made before the original copyright expires is valid against the world if the author is alive at the commencement of the renewal period. So that is pretty key, and that's important, especially when you watch the movie, or I keep calling it a movie, the next video about the movies and how they've changed hands. And that case that is involved is called Stewart versus Abend. That's what you're going to learn about. And the question was derivative works under assignment of renewal. And the case says that they revert to the original copyright owner's heirs if the owner dies before the renewal period. And I'll just give you a little background on that case. So what about derivative works prepared by the assignee? The author of a short story. So a derivative work, as we've mentioned a number of times, it's a work that derives from another work. The author of a short story assigned motion pictures rights to a production company, along with the motion picture rights during the renewal time. The production company made a film, Rear Window. It's directed by Alfred Hitchcock and starred Jimmy Stewart and Grace Kelly. The short story author died before the renewal term. So under Miller Music, the assignment of renewal rights was ineffective. The production company argued that it should at least retain the right to show a film that it made during the initial term. The court said nope. That's the Supreme Court. Said nope, holding that all rights reverted to the author's heirs. So you take these cases together. It means that assignments of renewal rights were effective, provided the author survived until the time of renewal. If the author died, all rights reverted to the author's heir, and even derivative works prepared during the initial term could not be distributed or performed without infringing copyright. Now, these terms, all of these concepts that we've learned, you're going to see in the video. It's going to talk about this case in this movie, but it's also going to talk about It's a Wonderful Life, how it was in the public domain and how it's come out of the public domain. So yes, and it gets complicated. So watch the video. If you have any questions, let me know. Sound recordings, they have special rules. Sound recordings made pre-1972. were not protected under federal copyright. In 1971, Congress amended the 1909 Act to include sound recordings only fixed on or after January 15th, 1972. Sound recordings fixed before that date were not protected by federal copyright. Lots of old songs were subject to litigation and still are subject to litigation. Those songs that are recorded in the 60s, especially as it relates to streaming and digital use. However, does that mean that they're not protected and they're in the public domain? No. So if you want to use a 1960s song for one of your projects you're working on, I highly do not recommend it, because it is still protected under state common law, at least until 2067. New York gives perpetual protection to pre-1972 song recordings where the alleged infringement occurs in New York. So these older songs are still protected under state law. However, on October 11th, 2018, President Trump signed into law the Music Modernization Act, which we'll discuss a little bit more in a couple weeks. But because it affects copyright durations, I want to mention it right here. This act creates a new collective to offer blanket rights to digital downloads, ending the need to secure rights for individual copyright holders. It also creates a new federal protection for sound recordings made before 1972 and used by digital radio, which were previously governed by state law. So this only applies to sound recordings pre-1972, the old classics, because from 1973 forward, sound recordings became protected under the Copyright Act, the Federal Copyright Act. So this puts it within the realm of the federal copyright protection songs that are pre-1972. So they get 95 years from the first publication plus a transition period, depending on the year of the first publication. And we'll discuss more how this works in a couple weeks when we talk specifically about music. So how long can copyright protection last? Well, as you can see, the works from 1923 entered into the domain name in 2018. Well, at the beginning of 2019. They expired at the end of 2018. So this keeps going on and on and on, and the question has come up to the Supreme Court whether extending terms violates the First Amendment, which means a right for other folks to express themselves due to creation and being able to expand on works that are in the public domain. But if you keep extending works so the public works don't fall into the public domain, there was a question on whether or not that was creating these extensions and violating the First Amendment is what Congress was doing. And again, the issue came before the Supreme Court, whether the continuous extensions, because the clause for copyright in the Constitution says for limited terms. Congress can do this, can control and make laws related to, inventions and authors' works for limited term periods, and they keep extending it. And the court in Elder versus Ashcroft, I think this is another Justice Ginsburg case. It's in the book if you want to read it in full, where the court said no, they are within their rights. They're not making it in perpetuity. They're limiting to it. They're putting limits on it. So it's constitutional for them to do that. So we will see. They last a long time. Can trademark law effectively extend copyrights? And the Supreme Court answered that question as well. The facts of this particular case, Dastar Corp versus Fox. 20th Century Fox had held copyrights in videos about World War II, but the copyrights had expired due to failure to renew. Dastar subsequently republished the videos, after removing credits to the original producers. Fox could not sue for copyright infringement because they didn't renew. But Fox contended that by failing to properly attribute authorship, because they didn't put authorship on it, because they took the credits off, Dastar falsely attributed the origin of the goods in violation of trademark law. But origin of goods, the court held, refers to the producer of the tangible goods that are offered for sale and not to the author of any idea, concept, or communication embodied in the goods. So trademark law would not provide a cause of action for failing to attribute to the author. And it was Justice Scalia who wrote this decision. He noted that the court in the past has held that the Lanham Act does not exist to reward manufacturers for their innovation in creating a particular device. That is the purpose of the patent law and its period of exclusivity. Therefore, claims about authorship cannot be used as an end run around the underlying philosophy of a time limit on exclusive ownership of a copyright or patent. Allowing such restrictions on a public domain work would serve, as Scalia wrote, to create a species of mutant copyright law that limits the public's federal right to copy and to use expired copyrights, and that would effectively create a species of perpetual patent and copyright, which Congress may not do, according to the Constitution. But Scalia did note that if Dastar had instead purchased the post-1988 videotapes and copied them, that would have been a clear copyright infringement. So no, you can't use trademark law to extend copyrights. So that is the completion of the discussion on duration. Make sure you watch that video to see how all of this works together. All the concepts that we talked about in formalities and duration work.